Good afternoon, ladies and gentlemen. Welcome to County Court of Law number 6 in the Bexar County Veterans Treatment Court. Today is a motion to revoke probation docket scheduled for 2:00 p.m. on Wednesday, the 10th of March. We have several cases today, starting with cause number 574145, State of Texas versus Jamal Roberts, represented by Daniel Rodriguez. Cause 529925, State of Texas versus Byron Johnson, represented by Andrew Del Cueto. Cause number 629455, State of Texas versus Taylor Marchand, represented by Jaime Cavazos. Cause number 512773, State of Texas versus, looks like Jose Torres Rangel, represented by Robert Jimenez. Cause number 633247, State of Texas versus Ivet Rodriguez, represented by John Reitmeyer. Cause number 621352, State of Texas versus Juan M. Rodriguez, represented by Mr. George Sharman. And cause 645148, State of Texas versus Eli Perez, represented by Mr. Paul Vasquez. Let's start with Mr. Rodriguez case, cause 621352, State of Texas versus Juan M. Rodriguez.
Your Honor, Mr. Rodriguez is running late. He has the Zoom in Comal County right now.
Okay, no problem. He's our
Judge, may I approach? We're here on Mary Burchin.
Okay, what are we doing on Ms. Bertram?
Mr. Maru is in charge of that.
Hey, Judge, Mr. Sharman, I didn't even think this was necessary. I was just going to go ahead and submit the dismissal. Judge, these are extenuating circumstances. This is the case that I referred you to. She's a 21-year vet. She was a perfect candidate for the VTC. However, she's had multiple back procedures. And the last time we checked, was only able to get around in a wheelchair, and with the convenience of her husband as well, doing all the driving and everything. The DWI had no alcohol in her system. Everything that was in her system was prescribed by a doctor who also recognizes now that what they prescribed, that they're taking more care now on what they prescribe her after seeing the effects. There was no crash involved. As I said before, there was no alcohol. Mr. Sharman and I, in the interest of justice, I have required her to complete all the classes, which she has done. She also, because she cannot do community service, she made a donation to the Wounded Warriors Foundation in lieu of that. And I think that's Mr. Sharman just kind of wanted me to bring that up to you, and I would be submitting the dismissal. It's already done. I just need to click it and send it to you.
It's okay with the state. It's okay with the defense. It's okay with me. So send it over. I'll be happy to sign that, and we'll move along on Ms. Bertram. Will that be sufficient, George, on that one?
That's correct. Can she be excused now?
Are we still waiting on Mr. Rodriguez?
Don't know. Oh, he's not there?
I'm here.
Are you there, Mr. Rodriguez? I do see you. Let's start with Mr. Rodriguez's case, George. Is that okay?
Your Honor, that's a defendant. That is not Daniel Martinez, Rodriguez.
Juan M. Rodriguez.
Okay.
I see Juan Miguel Rodriguez in an Army uniform. Airborne.
Oh, okay.
Yes, Judge.
So, Mr. Sharman, are you ready to proceed on that one?
He's out. Something kicked him out. I'm sorry, Your Honor. Let's see if he comes back on. Here he comes. Here he comes. Sorry. Okay. He's back.
Mr. Sharman, are you back with us?
Sorry. There you go.
Oh, there he is. George, can you hear me? Your microphone is off. There you go.
Yeah, I was kicked off accidentally, I think.
Are you ready to proceed on Mr. Rodriguez?
Yes, I have a couple of comments to make about it too. So I don't know.
Hang on just a second. Mr. Rodriguez, what rank are you, sir? I don't want to call you Mr. Rodriguez when you're active military guy.
Judge, it's Staff Sergeant Rodriguez.
All right. Staff Sergeant Rodriguez, stand by. Mr. Sherman, go ahead.
Judge, my client has been in the program. He's been doing pretty well. And not only that, he's continued to serve our country. He's been working in the Valley on the COVID-19 situation and helping out. His probation has expired. And we're asking that the court terminate him from his probation. And, I don't know what the state's position is going to be, but we feel as though he's completed his requirements with the court.
Okay, well, at this point in time, let's go formal on this thing and let me make the proper announcements. Once again, this is cause 621-352, State of Texas versus Staff Sergeant Juan Miguel Rodriguez. Mr. Rodriguez, got two documents in front of me I need you to identify your signature on. One is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, and it purports to have your signature on it. Is this your signature, sir?
Yes, Your Honor.
And Mr. Sharman, as attorney for Mr. Rodriguez, is this your signature on this document, sir?
It is.
And Mr. Rodriguez, I have another document entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication and the defendant has a limited right of appeal, unquote. Is this your signature on this document, sir?
Yes, Your Honor.
And Mr. Sharman, is this your signature also on this document as attorney for Mr. Rodriguez?
It is, Judge.
This is a motion to enter adjudication of guilt and revoke community supervision. My understanding is this is an uncontested motion to revoke probation. Representing the state is either Alexis O'Connor or Nicholas Maru. Representing the defense in this case is Mr. George Sharman. And Ms. Susan Gross, representative of the CSCD. Ms. Gross, please raise your right hand. I'll swear you in at this time. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir, I do.
Thank you. Mr. Sharman and Staff Sergeant Rodriguez, on your motion to enter adjudication of guilt and revoke community supervision, how do you plead?
Well, we're going to plead true only to the presence of alcohol. It's the question about how it was obtained there.
I would say that would be 2A and 2B that says that Mr. Rodriguez consumed alcohol.
Well, we're going to say there was alcohol, but we're not saying that he consumed it, that it was.
How about he pleads true with an explanation to 2A and 2B with what is still in question is whether he consumed it or it was somehow else arrived in his system. Is that kind of where you're coming from?
It is, Judge.
And are these scram violations, Ms. Gross, both of these?
Yes, Your Honor, they are.
All right, so the defense, I guess it's possible if you pour a bottle of alcohol on your scram bracelet on your leg, you're going to get a positive. And that's another one of your issues?
Well, there's also these sanitizers people are constantly putting on their hands, and there's fluids, especially in, places where they're.
All right, well, for purposes of the record, let me make sure I'm clear. You're going to plead true to 2A and 2B, and the wording in it is consume alcoholic beverages, but you want to put on evidence that shows that he didn't really consume it. It was sort of a byproduct of his job or something. Is that correct?
That's correct.
All right. All good. Ms. Gross, would you please advise the court and the parties of the status of Staff Sergeant Rodriguez probation, please?
Yes, Your Honor, this is the third violation report, second motion to revoke. His reporting has been good. We last saw him on February 25th of 2021. He does reside out of Bexar County and reports out of Mission, Texas. He is paid in full $1,222. He's completed 48 hours of community service, DWI education, victim impact panel, and the CATSNP program. He's had 2 alcohol violations that were obtained through a scram device, which registered on December 25th of 2020 at 0.025 and on December 26th of 0.030. This case is expired as of February 17th of 2021. His officer is recommending that his probation be extended for a period of 6 months and that he remain on the scram device for that term. He provide weekly drug testing through Hidalgo County Probation Department. He has no criminal history.
I know you're not the case officer on this case. Do you agree with that recommendation from your department?
Being that he has had prior alcohol violations, Your Honor, I think that it would be a good idea that he does remain on probation and remain supervised at least for a while longer.
State recommendation?
Along with probation, Judge.
Okay, Mr. Sherman, you want to go ahead and point out the specifics on your argument about the fact that this does not have evidence of actual willful, intentional, and knowing consumption of alcohol by Staff Sergeant Rodriguez. Go ahead.
Well, if you'll recall what she just said, I mean, the level is extremely low. It's at 0.02 and 0.03, all of which obviously do not indicate intoxication. And they don't indicate that prior to, at any point in time, there was an alcohol reading that was higher. And as a consequence, there was no time for him to go down from alcohol a greater amount to an alcohol concentration of 0.02 or 0.03. So as a consequence, what we have is a momentary amount of alcohol being registered on that scram device, which could be at that very low level an interferent. It does not, we say, indicate that it was from consumption, because there's no indication of consumption in prior scram notations. And if you're interested, I'll let him talk to you about that, Judge. He can describe it.
I understand your side of it. I do have a couple of questions for Ms. Gross. Ms. Gross, this was a scram ankle bracelet positive for alcohol. Is that correct? On 2 occasions?
Yes, Your Honor, that is correct.
My recollection of in the past, we never got any kind of details on a scram hit for alcohol. It was either positive or it was negative. We didn't get any amounts. Is that a change in the capability of the scram bracelet?
Yes, sir. They have recently started giving us numerical figures.
Okay. Would you agree with Mr. Sharman that 0.025 and 0.030 would be considered low alcohol content from the probation department's perspective?
We consider anything below a 0.02 to be questionable. Anything above a 0.02 does indicate alcohol consumption.
And Judge, if I may,
Sure.
looking at, I hear what Mr. Sharman is saying, but if you actually look at the violation report, it details, looks like 30-minute increments. Am I correct, Susan, on that?
Yes.
To where from 12:25:20, starting at 10:12 p.m., we have a register of 0.017. 30 minutes later, it went down. 30 minutes later, it went back up to 0.025. Then it went down again 30 minutes later. So we have 30-minute increments going all the way from December 12/25/20 to 12/26/20. So
What time of day?
It goes from 10:12 p.m. until 4:23 a.m. So Christmas night until the following day, it looks like a continuous alcohol consumption period.
Well, or an alcohol registration period. Would you agree to that?
yes, because there is no proof of consumption, we would have to agree that is alcohol registering. Yes.
All right.
And so this actually occurred on Christmas Day, night, and early morning of the 26th of December. Is that correct?
Correct,
Yes,
Judge.
Your Honor.
And Mr. Sharman, are you saying he was working at that time and therefore had some sort of exposure to some sort of chemicals or something that he does in his job?
I believe that's correct.
All right. Can I have your permission to question Staff Sergeant Rodriguez on a couple issues?
Yes, sir.
Hey, Sergeant Rodriguez, number one, thanks for your service. What is your actual job with the Texas Army National Guard?
Judge, currently we're on the COVID response. So our current mission right now is supplying different agencies with a supply PPE, which does include hand sanitizers, surgical masks, N95 masks, COVID test kits. And we supply those to different agencies from DPS to schools to nursing homes.
So do you have an understanding of what substance might have been exposed to your ankle bracelet on Christmas Day night or early morning of the 26th of December, 2020 that would have caused these positive on the scram bracelet?
No, Judge, because we do have typically from time to time where some of these pallets that we receive the hand sanitizers, because we get pallets of all kinds of supplies, and they tend to tip over and bust whatever. We got to clean it up. So my recollection, I do not know where that whole the consumption or the alcohol violation came from. As far as that time, I couldn't tell you, Judge, exactly. I'm trying to recollect. I got text messages from what I did that day, and all I know is that for that evening I just ate, but during the day we did work and did mess with a hand sanitizer to deliver for deliveries.
Were you on duty during these hours of late night on the 25th of December to early morning on the 26th of December, or were you just home sleeping? What were you doing?
We got off of work around 1800, Judge,
That would be
that
6 yeah.
That evening, and went to a family for a dinner, had a brisket and pot roast, and got home by 2100, and slept early because we traveled to Fort Worth the following morning at 0500.
Okay, so you didn't exactly answer my question. So you were not actually on duty with the
On duty?
military during the hours they say these violations occurred?
No, Your Honor.
Okay, that's fair. And how long have you been in the Texas Army National Guard?
19 and a half years, Judge.
So are you eligible for retirement in 6 more months, plus or minus?
Yes, Judge. My official date is August 16th.
And do you plan on retiring or staying on active duty for 30?
Given my physical ability right now, currently, I'm not able to extend anymore, Judge.
Okay. Mr. Sharman, do you have any questions based on mine?
No, I don't really, Judge. I just, maybe I could ask him a couple of things about, at the house, and then I'll turn him over to you, if you don't
Sure.
mind.
Take your time.
Sir, Mr. Rodriguez, do you keep hand sanitizer in your house?
Yes, sir. I have hand sanitizer here at the house. I have Lysol, which I used that day. And again, I took pictures and I sent it to the probation officer of what I had used that day. And she had advised me that unless I am consuming those products, it would not come out as a violation.
And obviously you wouldn't consume those products, would you?
No, sir.
Were those products in proximity of you during that period of time late at night?
Yes, sir. Because when I used Lysol that day, I tend to wear shorts around the house, and I use Lysol in the restroom, in the kitchen, whatnot, and because we have hotels that are provided to us, so I rarely stay here in the hotel. So that evening, I cleaned up here at the apartment because I was fixing to leave for a couple of days. I used Lysol and whatnot, and then when I was advised of the violation, I sent her the pictures of what I used that day, and she told me same thing, that unless I was consuming these products, I would not get a violation.
Pass the witness.
Hey, you have any questions for Staff Sergeant Rodriguez?
No, Judge.
Got 3 options for state and defense on Mr. Rodriguez's circumstance. I can revoke him. I can take away his deferred adjudication probation, find him guilty of the offense of obstruction of a highway, sentence him to 6 months in the Bexar County Jail, and assess a $2,000 fine. Option 2, I can grant the state's motion to revoke his deferred adjudication probation, adjudicate him guilty of the offense of obstruction of a highway, continue him on probation, and probably keep him on a scram bracelet, and probably give him a 6-month probation period of time. But Susan, correct me if I'm wrong, he's basically done everything on probation we've asked him to do, including reporting properly, even though he's in McAllen, on active duty with the Texas Army National Guard, except for these basic 2 alcohol violations. Is that correct?
Yes, sir, that is correct.
Okay. And number 3, George, in good conscience, since all the evidence is not really on Staff Sergeant Rodriguez's side, however, I have great respect and admiration for Staff Sergeant Rodriguez since he's volunteered to be in the military and do the job he's doing. And he also has the best lawyer in town. Other than that, he might be on his way to jail, but I think under the circumstances, the mitigation is if I term him unsat, that will not affect his career path, and he'll still be able to retire from the military, and we can move on from there. Which option would you like, Mr. Sharman?
Well, that sounds just fine to me. Terminate him on set.
And state, does that be agreeable to you?
Yes, Judge.
Okay. Mr. Rodriguez, the court accepts your plea of true with an explanation to 2A and 2B on the motion to enter adjudication of guilt and revoke community supervision. I deny the state's motion to enter adjudication of guilt and revoke community supervision, and I order your probation terminated unsatisfactorily. Anything further from the state or the defense on Staff Sergeant Rodriguez?
Nothing
Okay.
from the defense, Judge.
Good luck, Staff Sergeant Rodriguez. And
Thank you, Judge.
Carmen, y'all are out of here.
Thank you, Judge.
Okay. And we've got Jamal Roberts, cause number 574-145. State of Texas versus Jamal Roberts. This is. And
Your Honor, I'm present on his behalf.
motion to revoke community supervision. Mr. Roberts, I have two documents in front of me I need you to identify for me. One is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have your signature and your attorney, Mr. Rodriguez's signature on it. Is this your signature on this document, sir?
Yes, sir.
Thank you. And Mr. Rodriguez, is this as attorney for Mr. Roberts? Is this your signature on this document, sir?
Yes, Your Honor.
Thank you. Mr. Roberts, the next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked the revocation of the defendant's community supervision. And the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Is this your signature on this document?
Yes, sir.
And once again, Mr. Rodriguez, as attorney for Mr. Roberts, is this your signature on this document?
Yes, Your Honor.
Okay. My understanding is this is an uncontested motion to revoke probation. Is that correct, defense?
Yes, Your Honor. I was hoping this could be like a pretrial setting on the motion to revoke.
This is not a pretrial setting. This is an actual motion to revoke probation. We don't have pretrial setting.
Okay. Your Honor, I've attempted to confer with the state. I haven't heard from them. I was hoping I would have that opportunity.
You're going to get a chance to hear from them here shortly. Okay. On the motion to revoke community supervision, Mr. Roberts and Mr. Rodriguez, how did the defendant plead?
Your Honor, may I have a breakout room with my client?
And I guess that would be fine. Pat, we want to send them out to a breakout room. We're going to take up another case and then you can come back and we'll kind of start over on yours. Is that okay?
Yes, Your Honor.
All right, Pat, can you send them to a breakout room?
Pat, you're muted. We can't hear you.
Yes, I'm putting you in breakout room number 1.
Thank you.
Okay, next in line, I've got cause 529925, State of Texas versus Byron Johnson. And I've got Andrew Del Cueto, but I see Judge Joey Contreras, I assume, is going to represent Mr. Johnson for this hearing. Is that correct, Judge? And Joey, your microphone is off.
Well, Roland is here, Your Honor, as well.
Hey,
Roland
Judge.
Ramos.
Look at that. We have all kinds of lawyers here.
Yes, we do.
Also,
Both of us are here on behalf of Mr. Johnson. If the court will entertain us
no problem.
both to be heard.
So representing Mr. Johnson are both Judge Joey Contreras and Attorney Rolando Ramos.
Yes, sir.
My understanding is this is a third amended motion to enter adjudication of guilt and revoke community supervision. Mr. Johnson, I'm looking at two documents. One is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have your signature and your attorney's signature. I think this one's signed by Mr. Del Cueto on it. Is this your signature on this document, sir?
Yes, sir.
Thank you. And Mr. Ramos, I assume, is this Mr. Del Cueto's signature on this document?
It is, Your Honor, as the court's aware, we do that for single point filing for discovery. So because it's a firm, we use Andrew's bar number. So I apologize. Everything goes to him, but
Not a problem.
we're all members of the same firm.
I'm an attorney in the same firm. We're all good.
Yes,
The
sir.
next document I have, Mr. Johnson, is entitled Trial Court Certification of Defendant's Right of Appeal. which is marked, quote, is an adjudication of guilt following a deferred adjudication. The defendant has a limited right of appeal, unquote. Is this your signature on this document, Mr. Johnson?
Yes, sir.
And apparently Mr. Docket also signed this document. Would that be correct, Mr. Ramos?
Yes, Your Honor.
And Mr. Ramos, my understanding is this is an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
Yes, sir. It will be true with an explanation if the court will hear us, Judge.
That would be fine. Okay, so on the third amended motion to enter adjudication of guilt and revoke community supervision, Mr. Johnson, how do you plead, sir?
He's going to plead true, Your Honor.
All right.
Good.
And Ms. Gross, would you please advise the court and the parties of the status of Mr. Johnson's probation?
Yes, Your Honor. This is his second violation report. First, motion to revoke. He has performed very poorly on probation in that he only reported one time. We've not seen him since April 26th of 2017. He does have a new DWI offense pending. His case is paid in full. He did complete his 48 hours of community service. We have no record of any drug testing being done because he never reported. He did not complete DWI education, victim impact panel, or CATSNP classes. When he was active on Smart Start testing at 6 times a day, he did have 2 high BRACs, the first one on April 29th of 2017, registering at 0.019, and then another one on July 22nd, 2017, registering at 0.027. His device did go into lockout on March the 7th of 2018, and they have since written off the device. He has no other criminal history other than the pending DWI, and the probation department is recommending revocation.
State, have you got a recommendation on Mr. Johnson's circumstances? Or you want to hear from the defense first? He may have some mitigation you want to hear before you make your recommendation. So defense, let me start with you, if I may.
I'll hear from the defense, Judge.
Sure, go ahead.
Judge, if we may, and Joey, I'm going to, Judge Contreras, if I'm going to go ahead and start real quick. Judge, Mr. Johnson, everything that's detailed here, unless Mr. Johnson wants to clarify something, we didn't represent him on this prior case. We cannot speak to any vet court screening back in 2017. So I'm not going to purport or try and even begin to guess about why he wasn't in your vet court on this case. I can tell you this, Judge, that Mr. Johnson retired as of January 29th of this year with 26 years in the military. He has been a soldier serving honorably active duty, retired at the rank of E7 honorably. We have a DD 214. And he served as a 92 Mike, Your Honor. 92 Mike is a mortuary affairs person. He's been downrange. He was downrange a few blocks from Saddam's palace. He was downrange in Afghanistan. He's been downrange in Central America. And the reason he would go was to put people in pouches and send them home. And for 26 years, since advanced individual training, he has. Now, I'm not here, there's no excuse for Byron not reporting. And I would imagine most people in this room will shake their heads and go, man, you stop reporting. I'm just offering the court an explanation at around this time. When he started this probation, Judge, he got sent on a mission down to Central America, to San Jose Island, with a unit on an ordnance mission. And of course, they send 92 mics because if something blows up, people like Mr. Johnson have to put them back together what they can and let the family see it. He's done that honorably, Judge. But over the years and in learning about this, and Joey can speak to it, it takes a toll on a person. A person can only see so much death. And I'm not talking about, I get it. And there are people in this room, I'm sure, that have served in combat. I have not. I can tell you that is something that I wouldn't begin to say I get it, because I don't. But Byron saw the faces of death every day. And to kind of use his words, he saw enough death and just when he went down to San Jose and came back, that was it. And until he got out these years later, which finally he finished out here at Fort Sam, and wants to never see death again and wants to never deal with this again. But those faces haunt him, and he didn't seek comfort. He didn't seek counseling. He didn't seek anything. But many people dealing with 92 Mike suffer from PTSD, not because they have a gun being shot at them, but because all they see are the horrors of war. So, Judge, there is no excuse for him disrespecting this court. He follows orders, and he did that honorably. And there's nothing in his record that indicates otherwise, but he didn't follow this court's orders. And he's violated, and there's no excuse for it. We can offer the court this, that he's being screened through the VA on April 12th for Via Serena. He wants to go through this because he does have depression. He does suffer from depression. He does suffer from PTSD. None of this going through before this. He just said people in his MOS and like MOSs and most people, he says, look, you just deal with it. You don't sit there and make excuses for it. You do your job even when it gets harder and harder every day to tell families and try and patch bodies together so they can be viewed. And even when families don't want a service and things like that. And he's done it very well. So, Judge, he has a new case. He is retired now as of January 29th. And the court has options, and you can sure as heck revoke him. And there's nothing that says he doesn't deserve to go to jail for this. But, Judge, we can also help fix him because I think we broke him. And why don't we try and fix him and make him report? He's on scram. He's been on scram now at least a month. And let's make him do what he didn't do last time on his new case, starting with treatment at Via Serena and following up with your conditions of probation. And in this process, we're gonna, as a county and as a country, nurture Mr. Johnson back to some normalcy in his life, and give him his life back. And I'm not saying that not other people have earned it, but I think he's earned it. He turned his back on this probation for a multitude of reasons and never looked back. But he can do this, and he's committed to doing it, and he's taken the steps now in getting the screening set up. That's the earliest appointment for Via Serena, or for the VA, forgive me, to be screened for Via Serena. And we'd ask the court respectfully to consider the alternative to incarceration and allowing him to get better in the process.
State recommendation?
Judge, we're willing to go along with anything that you have in mind. I just want the court to be informed on what's going on here. The state's position is that had he perhaps gone to some of these classes that had been ordered, that maybe this wouldn't be such a situation. They address certain things. I understand it's not the same that you would get in the VTC. However, they would address some of his addictions and get to the root of it on what's going on. Second of all, after looking at this new DWI, it is extremely aggravated. So the idea that I feel for Mr. Johnson. I understand I don't understand what he's gone through, but I can't even imagine. But at the same time, here we're at this point where had he done what he was supposed to do, maybe he wouldn't be in this position in the first place. So the state is going to stick by with revocation. And if you would like, revoke and maybe have him either serve his term inpatient at Via Serena, if that's possible, or however you would like to go about it, Judge.
Okay, before I get into my thoughts on the issue, Ms. Gross, what is the loiter time for getting a gentleman into status at this point in time?
Let me double check that for you, Your Honor. I have it right here. I believe it's about 6 to 8 weeks at this point.
Sergeant First Class Johnson, status is what we call substance abuse treatment facility, and it's our county inpatient drug alcohol rehab facility. The problem with the VA is the longest inpatient program they have that I'm aware of is exactly as Mr. Ramos stated via Serena, and it's only 28 day. So that barely.
Judge, can I offer an alternative? Forgive me, I didn't mean to speak over your honor.
Go ahead.
Can I offer an alternative as well?
Sure.
We can, and we've spoken with them recently, lifetime recovery would be at lifetime recovery for 90 days. And we can have him in there. I'm comfortable representing to the court. We could have him in there definitely within the next week and possibly as early as Monday in lifetime recovery.
Who's going to pay for that, Mr. Ramos?
Well, Judge, it's two ways. It's one of them is under scholarship and funded. If he has insurance, it can go through his insurance. It can also be private pay. Lifetime recovery, as the court's aware, state pretrial, federal pretrial, county uses it. Everyone that uses it, it has funding available to it. We use that program regularly for our clients. He can wear a monitor there. It's not a program where they won't let him have SCRAM or even GPS if the court were inclined to have that. That doesn't interfere with their treatment programs. Like I said, we use it regularly, so we're familiar with that. That is an option for the court that would have him in treatment right away, Judge.
Judge?
Yeah.
The wait time right now is 6 to 8 weeks after he has completed his medical evaluation to determine if he is even eligible. But we have the other concern of the fact that he would not be eligible as long as he has a pending DWI. And thirdly, this case is expired. The only way that you would be able to do it is a reformed judgment and put him on regular probation.
I understand.
Judge, if I could present you.
Defense, with your permission, let me talk to Sergeant First Class Johnson, if that's okay.
Yes, sir.
Hey, Sergeant Johnson.
Yes, sir.
I mean, you spent enough time in the military. You knew that not reporting was going to get you in trouble. I don't understand the reason why you became a fugitive for so long.
First of all, sir, I want to apologize for not following your orders by reporting, number one. Two, as you just stated, sir, being in the military for so long, definitely know the pros and cons of following, rules and regulations and guidelines as well, sir. But I will offer to you, Colonel, that I felt like I had a stigma, and you being in the military, this stigma, stuck with me. I've never, been in any kind of trouble, and I felt the anxiety that I failed to let my primary care managers on the military installation know to get me help or medicine to be able to cope with, anxiety and depression, sir.
Are you working, Sergeant First Class Johnson? What are you doing?
I am not working at the moment, sir. However, I did get accepted to do an interview tomorrow or Friday, sir.
And who is that with? What organization?
It's called Virgil Optimal. What they do, sir, is they build security cameras for houses and businesses and things of that nature, sir. So people will be able to, monitor their property.
Ms. Gross, you have in front of you a document that will tell us what Sergeant First Class Johnson's original sentence was with regard to fine amounts and whatnot?
Yes, Your Honor. He is on deferred, and his original fine was $850.
And I assume, 48 hours community service?
48 hours community service. He did complete that, Your Honor.
And victim impact panel, DWI education, CATSNP, those things?
Yes, and the Smart Start Mobile.
Judge, if I may, before you,
Sure, go ahead.
if it's okay with you, Judge, court and defense, what I would like to propose is maybe getting rid of this and placing him on probation for the new current DWI. Because it's going to come down the pipe eventually anyways.
The problem with that, and I'm gonna let Mr. Ramos jump in, the problem with that I perceive is, in order to do a competent defense job, the defense team is gonna have to get all the cards on the table and wait for discovery, and that's gonna take quite a while, if I were guessing. Is that accurate or not?
Judge, we can probably expedite this along, and we could do it on today's docket or in a docket in the next few days as the court's discretion. I think the state is proposing something that is reasonable and that we are absolutely willing to entertain.
Okay, legally, without having is there a lab report that has to be done, or was it a breath test? What is it?
Judge, we have a breath test. And additionally, all Coban and body worn camera and the crash report have all been uploaded. So,
we have received all discovery, Your Honor.
All right. So pursuant to state legal applications and the DA's policy, they could technically plead to that new offense tomorrow. Is that correct?
That is correct, Your Honor.
And Mr. Maru, you talked about aggravation on the new case. What are you talking about?
As long as defense doesn't mind me getting into that right now, Judge.
Technically, defense, probably I don't have access to that for purposes of this hearing, but if you want me to consider working
fine with it.
a deal, including him being on probation for the new case, I need to know that. Do I have your permission to inquire?
Absolutely, Judge. It's a report. We're well aware of the report, and we can speak to that briefly. But I have utter complete confidence Mr. Maru will represent the facts correctly.
All right, Mr. Maru, what happened on the new offense?
The judge, we have a breath test of 0.25, I believe. Additionally, there was an accident where he seems to have rear-ended an individual on a moped. It did cause some bodily injury, not serious bodily injury. The only thing I would have to do is get a hold of this victim, and even then, if they don't respond in time for our plea, I can always include restitution, if any, to that victim.
And how soon would a plea be able to be entered, Mr. Ramos, in a perfect world? This week or next week?
Judge, today being Wednesday, if we can, I mean, some of that will rest with the state, but we could enter a plea this week if the court wants to hear us this week. Absolutely.
Okay.
Judge, I can get an offer to Mr. Ramos by the end of the day as well.
Okay. And Mr. Ramos, take me by the hand, because my mere 42 or 3 years of experience at playing this game has led me to believe that any kind of, quote, inpatient programs, unquote, like you're talking about, you have the availability of, don't really work out very often. So, I mean, they're incredibly expensive unless the military or the county is going to pay for it. Tell us again and because here's what I'm trying to craft. If Sergeant First Class, excuse me,
Johnson, Judge.
Johnson is willing to accept responsibility on the new case, and you and the state can agree to whatever requirements you want on that one. The only issue I want is, it seems pretty obvious to all parties concerned that Mr. Johnson needs inpatient rehabilitation longer than what Via Serena can provide. The only access I have to our own inpatient, obviously, and you're aware of, is SATF and MIOF, the mental illness offender facility. I don't think he's qualified to go to, although PTSD might do that, but it'd be 120 days minimum. If you can get him into an actual day for day, 90-day inpatient program, anywhere that's
Judge, I want to clarify, Lifetime Recovery is a 90-day program. He lives there 90 days, sleeps there 90 days. It's 2 phases, 45 days, no working, no, just strict counseling. The tail end of that, he's still there. So he's living there in the facility here on the south side for 90 days. But then they start acclimating him. If he has a job, they drive him to his job, bring him back. They have their counseling sessions. This is covered by the United Way, the state of Texas. If he has private pay or health insurance, he can do that. Private pay runs, it's pretty expensive. We've had clients pay it. But Judge, we've used it for years. I've had very close friends use it up with their family. It is very successful. It is a very successful program, and I'm not going to tell you it's 100% successful, but that is the program, and we know the director, we know the admissions people well enough to call them on their cell phones and say, can we get this person screened and reviewed, and we'll do that. Of late, they have adjusted the way they've done things. It used to be they had to get screened by the Center for Healthcare Services, and it was taking too long. So now they've gone to direct screenings to get people bed space quicker. And we will begin that if the court ends up going with a program like that. We will begin working on that this afternoon with Lifetime Recovery.
Okay, and here's another key question for you. It's called an inpatient program. Do they lock the doors where you can't walk out even if you wanted to, or do they not?
Judge, I don't think that any program other than SADF is going to be a lockdown like that. You can put him on GPS and know if he leaves. Obviously, he's signing himself to jail, but I don't believe that it is a true high fence lockdown facility. I'd be lying if I told you, yes, I do not believe it is that type of facility. I think if he wanted to leave, he could. I think he understands now where he's at in his life. I don't think that will be an issue with Mr. Johnson.
All right, Sergeant First Class Johnson. I
Yes, sir.
have great respect and admiration for your military career. However, you went AWOL on me.
Yes, sir.
So I don't get a warm, fuzzy feeling. My job is not to trust anybody. So I apologize it's that way, but it's that way.
Yes, sir.
My questions for you are, the possibility exists, either A, I can order you to my SADF facility, which really is locked down, and even a crafty NCO like you won't get away, or we can let Mr. Ramos run with the ball and see what he can do commercially on getting you a more ritzy setup. And I don't think the state minds one way or the other as long as you're getting the proper treatment. Would that be accurate, State?
Correct, Judge.
Okay, so it's kind of a matter of control from my perspective. I have no control on the commercial side, and they could let you walk out the door the day after you got there, as far as I know. But as Mr. Ramos pointed out, I have the ability to put a GPS bracelet on you, which would probably be in the cards if we get this work today, and I would be able to find out where you go unless you cut off my GPS bracelet. And then you of course know enough now to know what the textbook solution to your problem is. As long in Bexar County jails, I can legally put you, and both Mr. Ramos and Judge Contreras will verify for you how quickly I'll do that. And I'm right on the tip of my tongue doing that today, but we're still talking about it. All right, state and defense, here's what I've got in mind. I'm going to grant the state's motion to revoke Sergeant First Class Johnson's deferred adjudication probation, find him guilty of the offense of obstruction of a highway, but give him basically the same sentence he had, but I'm going to add 120 days in SADF with the understanding that while he's waiting to get into SADF, which may be easily a month or more, if you can get him into your program for 90 days, he can go to that. Now, the downside of all this is I'm going to want him to report to the Bexar County Jail on Monday morning, and he's going to sit in jail until we find somewhere for him to go. And if you can get him in the new place or the new program in a week, then he's out of jail in a week. If it takes 2 months, he sits in jail 2 months. That's kind of what I got in mind. Is that something that the defense could live with?
Judge, we will begin working on Lifetime Recovery as soon as we end this Zoom with this court.
I'm not going to I'm not going to order him to report to the Bexar County Jail till Monday. So if you can get him in the facility or something before Monday, that's going to be beneficial for Mr. Johnson, because I think what the state and I want, and I'm sure you want, is to make sure this never happens again. So we got to change the way he thinks about alcohol. It's kind of where we're at.
Judge, we want to work on it quickly too. I definitely don't want to get him in the jail and then bring him out just because of risk of COVID and moving it to that facility. I'd rather be right where he's at. We'll work on it, Judge.
All right, Susan, I'm gonna need your help in a minute. Let me try and get this going. Okay. You're causing me a lot of trouble, Sergeant Johnson. That was a joke, sir. Okay, and clause number 5290925, State of Texas versus Sergeant First Class Byron Johnson. Mr. Johnson, the court accepts your plea of true to all conditions on the motion, excuse me. The third amended motion to enter adjudication of guilt and revoke community supervision. I grant the state's motion to revoke your deferred adjudication. I adjudicate you guilty of the offense of obstruction of a highway. I sentence you to 6 months in the Bexar County Jail, probated for 1 year. Assess an $850 fine plus court costs, 48 hours community service, probating all that based on your military service. DWI education course, DWI victim impact panel. Actually, I'm gonna make that DWI intervention because that's what he's gonna get on the next one anyway. DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, outpatient drug. Credit for all monies paid or any programs completed. 120 days in the Bexar County Substance Abuse Treatment Facility, with the understanding that the ball's in the defense court to provide the state and the court with specific information on an inpatient drug alcohol rehab program for a length of at least 90 days. I'm going to order partial GPS if it's not a lockdown facility, which apparently it's not. If it is a lockdown facility, we won't need that. That's sad if we won't need that. Okay, and Sergeant First Class Johnson is report to the Bexar County Jail at 0900, 9 o'clock a.m. on Monday, March 15th, 2021. Defense, you got my cell number. Once you get everything locked in place, if we can come up with a plan to get him into inpatient rehab without going to jail, I'm on it. I'm all for it. So what I'm doing is basically a fail-safe method that we're going to make sure there are no more problems before we get this one fixed.
Yes, sir.
Is that acceptable to the defense?
It is, Your Honor.
Is that acceptable to the state?
Yes, Judge.
And Judge, given that he's going to be on GPS, I'll just make one request of you, and if the court will consider it on that partial GPS, will the court consider waiving the fees on that GPS while he's at treatment?
Get me some sort of a income document, okay. And if you can verify he's indigent, absolutely.
Well, he's retired. I don't know how indigent that'll be, but we'll get you something.
I don't know either, but I didn't put him in this position, and I think Sergeant understands that.
Your Honor, what are we going to do with the new case? Do I need to reset it?
Oh, good point. And this is, I don't think I can make this part of the plea bargain, but my understanding is there's a current agreement between the defense and the state that by Monday, say, that y'all are going to enter into a probation plea bargain on the new offense, and I am available 24 hours a day to enter that plea whenever that comes about, and those cases will run concurrent. State, do you agree with all that?
Yes, Judge, and I'll have that offer to you, Mr. Ramos, by the end of the day.
That's fine. Thanks.
Sergeant First Class Johnson, you got any questions on all this? We went pretty fast through all this. Your microphone is still off, sir.
No, sir, I'm tracking all, sir.
All right, all good. Anything further from the state or the defense on Sergeant First Class Johnson? Susan, go ahead.
I have a couple of things just to clarify, Judge. So you're going to put him on probation for a year, and I didn't hear, is he going to be going back on a monitor of any kind at any time?
He would be on scram if we have to put him on a monitor from right now until he reports to jail. He's not going to need a monitor in jail, right? So we're not going to put a monitor on him until he gets out of jail in some capacity. If he goes to an inpatient program, he's not going to need a monitor either because they're going to be testing him weekly. Would you not agree, Rolando?
Yes, Judge, and again, whatever the court orders on that, we anticipate that we're going to have him in a program by Monday to avoid him having to go into jail, book in, and lose some days. What does concern me a little bit is setting this plea up in time. So Nick, we'll talk and see if we can't get something on Friday's docket. I just hate to do all this to get a jail docket if he's able to go to treatment right away. So. Judge, we'll logistically try and get this new case resolved.
What is the cause number on the new case so I can CC these things?
640-462.
And that's a DWI second, is that correct?
No, Judge, it's a DWI 0.15 or higher. First case was an obstruction.
Because this was an obstruction, I got you.
Okay, Judge, you ordered him to jail on Monday. Are you sentencing him to jail for a certain time period?
No, I'm remanding him without bond and I'm waiting for a status opening.
Okay, so.
But if we get an opening in another commercial inpatient program, then we're going to switch our sights on the new commercial program that Mr. Ramos is going to provide.
Okay, Mr. Johnson.
Yes, ma'am.
All of your paperwork will be done and sent to the court this afternoon, and then the court will send your paperwork to probation tomorrow. So we need to get all of your paperwork done and completed before Friday. So I need you to go physically to the probation department on Friday at 2 o'clock. And that's at 207 North Comal. And it's that 4-story building right across the street from the jail. You're going to go in and tell them that you're there for orientation. You're going to sign all your paperwork. And then, of course, Monday morning at 9, you'll turn yourself into the jail unless you're in a different residential program. If you fail to show up, the judge will issue a warrant for your arrest. There is a chance that the probation department might call you and ask to do your paperwork via a Zoom hearing prior to that. And
Okay.
then you would not have to go in on Friday, okay? So if you don't hear from anybody, you need to be there Friday at 2 p.m.
And Mr. Ramos, tell me again what the name of the residential program that y'all are going to apply to is called?
Yes, sir. It is called Lifetime Recovery. And it's been around for quite a while. It used to be known as the ARC back in the day, and it transitioned. And the female component of that is Alpha Home. And the Alpha Home, actually the inpatient part is at one place, and these ladies live right actually behind Central Catholic High School. Federal pretrial uses it a lot, Judge. It's a program I wish more of the courts would look at it. It's a good alternative and another tool for you all.
Okay.
Mr. Johnson,
Go ahead, Pat.
Mr. Johnson, because it is starting a new probation, I am going to be sending you an application and a data sheet that needs to be filled out, because that is what's going to be sent to probation so that they know you're coming. So right after I finish here, I'm going to send that paperwork, and you need to do it as soon as possible. So that way they can send it to probation. Okay.
Yes, ma'am.
Okay.
We'll do it here at the office right now, since he's in our conference room.
You want it sent there?
Yes, ma'am. That's fine. Send it to any one of us here, and we'll just do it while he's here.
Okay.
And Judge, if you can get his plea and him put on probation tomorrow and get the paperwork over to probation early enough tomorrow, they can do both sets of conditions on Friday.
I'll get it in this afternoon at some point or tonight at the latest.
Well, no, I'm talking about also on the new plea.
The plea won't be done until Friday.
But Sergeant First Class Johnson comes first and the rest of them come second. So that's the way it is. Okay, that's all I got, I think. Everybody's excused. And keep me in the loop, defense, on what you're doing, and keep the state in the same loop.
Will do, Judge. I'll talk to Mr. Maru right now. Judge Contreras, I apologize for not deferring to you. So no disrespect.
That's fine. Did a great job.
And if you guys can keep me in the loop too, if you're going to get him into a program before Monday, let me know.
Yes, ma'am.
Appreciate it.
All right. Judge, have a good afternoon, sir. May we be excused?
You bet. Good luck, Sergeant First Class Johnson. Thanks for your service, sir.
Thank you, sir.
And State, you've got two prosecutors with us today. Is there a chance that you could go out in a breakout room for a little while with Mr. Rodriguez to discuss Mr. Roberts' case?
Yeah, 1 second, Judge. Let me call Alexis real quick. We're not.
Mr. Rodriguez, I assume that's what you'd like to do. Is it not?
I'm sorry?
I assume that's what you'd like to do is have a conversation with the state on your case?
Yes, if I could try to work it out, I'd prefer that. Assuming that you would go along with any agreement we'd make.
We'll send Alexis in the breakout room, Judge. 1
We've got a
second.
lot of cases today, and that gives you enough time if one of the prosecutors is available to chat with.
Mr. Rodriguez, you can go back into one, and as soon as Alexis comes in, I'll send you.
Okay,
Send her in, okay?
thank you.
Uh-huh.
Okay, I've got cause 629455, State of Texas versus Taylor Marchand with Jaime Cavados. Mr. Cavados, are you with us today?
Yes, Your Honor. Good afternoon.
Okay, good afternoon to you. And this is a fourth amended motion to revoke community supervision. Is it Miss Marchand?
Yes. Ms.
Okay.
Marchand, Your Honor.
Ms. Marchand, I've got two documents for you to identify your signature on for me. The first one is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. Is this your signature on this document, ma'am?
On the defendant's signature, it is, yes, Your Honor.
And same question for Mr. Cavados as attorney for Ms. Marchand. Is that correct?
Yes,
Mr.
Your Honor.
Cavados?
It is.
Would that be yes, Mr. Cavados? I apologize, I missed it.
Yes, Your Honor.
All right, thank you. Next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. And is this your signature on this document, Ms. Marchand?
Yes, Your Honor.
And same question for Mr. Cavados as attorney for Ms. Marchand.
Yes, Your Honor.
And my understanding is this is an uncontested motion to revoke probation. Is that correct?
Yes, Your Honor. That is correct with some explanation.
Okay. So on the fourth amended motion to revoke community supervision, how does Ms. Marchand plead?
She pleads true, Your Honor.
Okay, we'll call that true with an explanation. And Ms. Gross, would you please advise the court and the parties what the status of Ms. Marchand's probation is, please? And Susan, your microphone is off.
Yep,
There you
sorry
go.
about that, Your Honor.
No problem.
Miss Marchand has performed very poorly on probation. We last saw her on March 5th. She did miss January and February of 2021. She's not made any effort to make any payments. She has a balance of $1,353 and is delinquent $693. She's not completed any of her 36 hours of community service. She did complete DWI education and the drug offender education program, but has not completed victim impact panel or an equivalent to the CAT-SNP program, being that she resides out of county. She is on the Smart Start mobile device, testing it 4 times a day. She has had 48 skips, 5 high bracs. She's been in lockout since January the 4th of 2021. She has had other people submitting blows for her on the Smart Start mobile device. And there's one incident where she is flicking off the camera on the Smart Start device. She has no criminal history. She's had 7 positive drug tests. 6 of them were via the alcohol on the Smart Start, and once for amphetamines. And she's also had 1 diluted drug test. Her officer is recommending 120 to 180 days at SATF, followed up by the aftercare program.
Defense, what are you requesting?
Your Honor, Miss Marchand has relocated with her parents, her dad and her stepmom here in the Valley. And I have spoken with her in detail. I'm very familiar with Marchand since she was like 12 years old. She understands that the fact that she has done very poorly since October when she was placed on probation. She understands the ramifications and she understands what she's facing. She's also advised me recently that she is pregnant, I believe about 8 or 10 weeks. So she also understands that it's not affecting just herself, but also now her unborn child. What we're requesting is for the court to consider to continue. I've spoken with Mr. Maru, and I believe we have an agreement to continue her and have her on weekly testing.
And Judge, in light of that new information, being that she is allegedly pregnant, SADF would not take her, and therefore we would recommend revocation in lieu.
Judge, if I may?
Sure, go ahead.
Yeah, we were trying to get her into a treatment program here in the Valley, and we were faced with the same dilemma where she was not able to attend due to her pregnancy. She is under a doctor's care since she returned with her dad, and she is getting doctor's care for a prescription for her medication. And she has assured me, and I've talked to her in detail, she has assured me she's committed, and she understands this is what she's facing, and she understands that she has done very poorly, and she has no excuse for that.
State recommendation?
Judge, coming into this, we did have an agreement. However, in light that this is news to me that she is allegedly pregnant, the state would be asking to alter an amend to include SCRAM, zero tolerance, a SCRAM for the duration of probation, extend her probation a year, and that she be enrolled in all of her classes within a week of today. Zero compliance or substantial compliance, zero tolerance.
Hey, Ms. Marchand, how long have you known that you're going to have a child, ma'am?
I've known for about 3 weeks.
I'm sorry, say again?
I've known for about 3 weeks.
3 weeks? Okay. And Susan, the amount that Ms. Marchand still owes is $1,353. Is that correct?
Yes, Your Honor. And of that, $500 of it is her fine.
Vince, can Ms. Marchand afford a SCRAM device at $350 a month for a year?
Yes, Your Honor.
Judge, if I may?
And Susan, if we wanted to keep Ms. Marchand on probation and we want to we need to extend her a year, what do we need to do with her on a time situation?
Judge, currently her expiration date is October 8th of 2021. Her original probation sentence was 1 year. So if you wanted to extend it another year, it would go to October 8th of 2022.
Basically, I want a year from like today.
Let me see, this is March, so 10, 11, 12, 1, 2, 3. So you would have to extend her 5 months. And it would give her an expiration date of March 8th, 2022.
No restitution on this case, correct?
I don't believe so, Your Honor.
I'm double checking, Your Honor. No. No restitution.
Ms. Marchand, are you working? What are you doing in the world these days?
At the moment, I'm not employed, Your Honor. I am currently seeking employment. I had an interview at Rudy's Barbecue, and I had found out that I was pregnant, so I was looking for a detox to go to due to the fact that I do take medication. And when I found out that detoxes don't take pregnant women, I started looking for jobs again.
Ms. Marchand, in cause number 629-455, on the fourth amended motion to revoke community supervision, the court accepts your plea of true to all conditions. On the motion to revoke your probation with an explanation, I deny the state's motion to revoke your probation or to continue on probation with all prior requirements and no sanction at this time, although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary?
No, Your Honor, you have my full attention.
Extending your probation to March the 8th, 2022, ordering Scram bracelet, which I think they call the Scram cam these days, in 5 days of today. Defense, is that going to be a problem?
Your Honor, she is in Cameron. Can you travel to San Antonio if you need to travel to get it within 5 days?
I'm sorry, where is she located, Mr. Cavados?
She's in Brownsville, Cameron County, Texas.
I think they have Scram in Brownsville, if I were guessing.
And just goes without saying, if we can waive condition 7.
Susan, has this probation already been transferred to Brownsville initially?
I do believe she was reporting down there. Yes, we have her showing that she is in Brownsville. But she was reporting to a regular officer. So no, I do not believe she was reporting out of county.
Will they accept the transfer of probation again?
They should, being that she now has a year left on probation.
Okay. Okay, DWI intervention, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program or equivalent, because you're not in San Antonio.
That's already a condition, Your Honor. Are you adding DWI intervention?
Yes, and I'm gonna want intensive outpatient instead of just a regular one. We seem to have an issue here.
So you want to waive the cat snip and change it to IOP?
Just leave them both there and we can waive them later, but do you want to, I mean, what do you want to do? You're the probation guy, you're the expert. Do we need to waive cat snip and just say intensive outpatient and be done with it?
Yes, please.
Let's do that. Credit for all done and paid, substantial compliance in all areas within 30 days. I'm going to register for every program she's assigned within 30 days. She may not start them within 30 days. I'm sorry. I want to register for them within 10 days. She may not start them in 10 days, but she'll be registered for them and she'll know what's coming. So she needs to get registered for the intensive outpatient, the DWI education, the DWI intervention, the victim impact panel, and she may have done some of these. I think she did DWI education already.
Correct.
And that's basically it. She needs to be on that Scram bracelet within 5 days. That's the biggie. And I'll put her on weekly report in UA if we can do that in Brownsville. Can we do that in Brownsville, Susan?
Yes, sir.
Now, if she shows me 4 clean UAs, defense, I'll take her off of that weekly report in UA business. But as of right now, we're kind of starting over on all this. And as Mr. Cavados is well aware, and Ms. Marchand may not be well aware, the textbook solution for what we're doing today is just revoke you and put you in jail. And they take pregnant ladies in jail. That's not a problem for them. And they have doctors in jail. So your attorney has saved you this time, but I'm here to tell you, it'll be the last time.
So she's fully aware of it. We've had a very good conversation and very frank.
Fair enough. Do you have any questions, Ms. Marchand?
No, Your Honor, I don't have any questions.
Okay. Your probation is now your full-time job. I understand we're having children, but we can do that at the same time we're successfully completing probation. So in 30 days, Ms. Gross is going to get back to me and tell me what you've done and what you're registered for and that sort of thing, what progress we made. And you start making money payments because you're way behind on monies apparently also.
Okay.
All right.
Thank you, Your Honor.
Have you got any other input for us today?
Yeah, Judge,
I
is there a
do.
transfer fee that she needs to pay to transfer it to Cameron?
We're going to transfer it to Cameron County, correct? So she has a probation officer in Cameron County.
All your payments are still gonna be made here. That's all gonna be gone over with her. Your officer will be sending you conditions via email tomorrow.
Okay, ma'am.
And you need to sign those and send them back. Then a different officer is going to contact you about transferring your case. And, Judge, it's gonna take a while to get that case transferred down there, so the UAs may not start right away.
I understand.
But as soon as she gets an assigned officer, we can start those weekly UAs. And as the judge said, once you have 4 clean ones, then he'll consider putting you back on monthly UAs. Okay? But if you do not hear anything from your officer by noon tomorrow, then you need to call Miss Minez, okay? You have her
Yes,
phone
ma'am.
number?
Yes, I do.
Okay. Do you have any questions about anything?
As far as the inpatient program, where would I be going?
It's here in San Antonio, but the judge didn't order the residential treatment.
Oh, okay.
Okay?
Alrighty.
We
Then
can
no-
go ahead and order residential treatment if you'd like. They won't take pregnant ladies, I'm afraid, but thank you for volunteering.
May we excuse?
Your number one priority is take care of this child. And if you drink while you're pregnant, that's going to affect the health of your child. And
Oh,
everybody's going to
absolutely.
be mad at you, especially me. Now, are you going to come up positive for anything colorful on your first UA? I mean, there's like, he had marijuana recently and is going to be positive for 30 days, something like that. You want to
I'm
tell
going to
us?
be honest with you. Before I found out I was pregnant, I did take a hit at a party. So I might come out dirty.
Marijuana?
Yes.
Okay. Then thank you for being honest with us. And that basically buys you 31 days of time that we're not going to hold that against you on a marijuana positive.
Thank you, Your Honor.
Anything further from the state of the defense on Ms. Marchand?
No, Judge.
Good luck, Ms. Marchand. This is your last chance. Your attorney will explain to you how lucky you are.
Thank you.
Your Honor. It's been a pleasure working on to be in your court.
Okay, are we ready to go back on Mr. Roberts? Did y'all get a chance to talk yet? Mr. Rodriguez, did you get a chance to confer with the state on Mr. Roberts?
He was here just a few minutes ago.
I see Mr. Rodriguez still here on the screen, and I see Mr. Roberts on the screen.
Well, there
I'm
he
here,
is.
Your Honor.
There he
Okay, we
is.
got Mr. Rodriguez, we got combo. Did you get a chance to confer with the state on Mr. Roberts' case?
Yes, Your Honor. Thank you for allowing that.
All right, can we go forward now on this hearing, and then y'all can make your recommendations and we'll move along?
Yes, please.
All right, back on the record on 574145, State of Texas versus Jamal Roberts. If I recall correctly, Mr. Roberts has already identified his signature, and Mr. Rodriguez has identified his signature on both the motion to revoke community supervision and the violation report. It's not the violation report, and the, hang on, I'm losing it. On the, stand back. Defendant's consent to motion to revoke hearing by video conference and the trial court certification of defendant's right of appeal. So those are squared away. And at this point in time, I have to ask Mr. Rodriguez and Mr. Roberts, how did the defendant plead?
Your Honor, he wishes to plead true to the 3 allegations and not true to marijuana.
Okay, so marijuana is 2, so not true to 2.
Right.
And I've got number 5, which is the reporting, I believe, failure
Right.
report. And number
True to
14,
that.
which is community service, and number
True to
15,
that.
which is DWI education program that hasn't been done.
True to that as well.
So true to 5, 14, and 15, all with an explanation. Would that be correct?
Correct, Your Honor.
And Ms. Gross, would you please advise the parties in the court of the status of Mr. Roberts' probation?
Yes, Your Honor. Mr. Roberts has performed poorly on probation in that he only reported 2 times. We last saw him on July 29th of 2019. He has paid $770 towards his fees. He has a balance of $917. He completed 35 of his 48 hours of community service. He had 1 positive drug test for marijuana. He has not completed DWI education, victim impact panel, or CATSNP programs. He was on Smart Start mobile testing 6 times a day. However, he's been in lockout and the device has been written off since November 15th of 2019. The case is expired as of April 28th of 2020. He has no criminal history in Bexar County. However, he does have 5 cases pending in Bastrop County. A possession of marijuana 0 to 2 ounces, possession of a controlled substance, penalty group 2, less than 1 gram, possession of controlled substance, penalty group 2, greater than 200 grams, possession of a controlled substance, penalty group 3, less than 28 grams, and an unlawful carrying of a weapon. These are not alleged on the motion to revoke because they did occur after the case had expired and we could not amend the motion. We are recommending that his probation be revoked.
Vince, what's your request, please?
Your Honor, we're asking as well, like we understand that this probation will be revoked based on his performance, but we're asking to deviate from the underlying sentence and impose a sentence that would allow him perhaps the chance to be released sooner rather than later. He has been incarcerated in Bastrop County Jail since February 9th, 2021, was transferred to Bexar County and has remained in continuous custody for over 30 days, it looks like.
And Susan, do you have in your records what the initial fine amount was on Mr. Roberts' case?
Yes, Your Honor, it was $800.
State recommendation?
Revocation, Judge. We would just ask for a sanction. What, it's 6 months is the underlying sentence. We would ask for 120 days, Bexar County Jail.
Mr. Roberts, the court accepts your plea of true to conditions 3, 14, and 15, and not true to condition 2, all with an explanation. On the motion to revoke community supervision, I grant the state's motion to revoke your probation. I sentence you to 6 months in the Bexar County Jail, assessing an $800 fine plus court costs, credit for time served, time and money to run concurrent. Anything further from the state of the defense on Mr. Roberts?
No, Judge.
Good luck, Mr. Roberts. Thank you, Mr. Rodriguez.
Your Honor, will he be getting credit for the time that he did from February 9th, 2021?
I'll be happy to write it down. I don't know if he'll actually honor my order, so to speak, but I'll be happy to give him credit for any time he spent in a jail anywhere during the period.
Mr. Rodriguez, if you call our clerks and give them the day that he was arrested in the other county, I guess from like today, they can calculate and give it to the sheriff's department. They will give him credit.
Okay. And Your Honor, I don't know if Mr. Roberts wanted to speak to the court on his own behalf. Would you allow him the opportunity to do that if that's what he wanted to do?
Go ahead.
Yes. As far as the breathalyzer, I was not in lockout. I completed it. Like I said, I finished. I termed out on that. Like I said, and I mean, like I said, I do admit that I stopped reporting. Like I said, it was due in part. Like I said, I believe my Travis County probation officer had given me the motion to revoke, and that I was waiting on correspondence from the Bexar County probation officer, which I never had any correspondence from her. And like I said, so I do apologize. I take full responsibility. Like I said, since then, like I said, I had 2 kids and had one in August and one in September of 2019. And then I just had twins in 2020, October. So I've had 4 kids since, like I said, so it wasn't my intentions on trying to avoid anything or run anything like that. Like I said, I never received any correspondence from the Bexar County probation officer. Like I said, but Other than that, like I said, and I did the MAD class as well. Like I said, I have the proof from that. But like I said, I apologize. I do accept full responsibility, and I apologize.
And Your Honor, the court summary does show that he did complete several of the classes that he was required to complete. I want to say the impact panel, as well as a intensive outpatient program.
Okay, thank you, Mr. Roberts. Thank you, Mr. Rodriguez. You're excused.
Thank you.
Okay. Let's see. Next, we've got Jose Torres Rangel, perhaps, or Rangel Torres, 512773 with Robert Jimenez. Mr. Jimenez, are you with us today? And I'm looking. Mr. Jimenez, I can see you, but your microphone is turned off.
How about now, Judge?
Microphone, there you go, you got it, thank you. Okay, once again, this is cause 512773, State of Texas versus Jose Rangel Torres. This is a first amended motion to enter adjudication of guilt and revoke community supervision. Representing the defendant is Mr. Robert Jimenez. Mr. Torres and Mr. Jimenez, I have two documents I need you to identify your signatures on before we get into this. The first one is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. And Mr. Rangel Torres, is this your signature on this document, sir?
Yes, Your Honor.
Thank you. And Mr. Jimenez, as attorney for Mr. Rangel Torres, is this your signature on this document, sir?
Yes, Your Honor.
And the next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked as an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. And is this your signature on this document, Mr. Rangel Torres?
Yes, Your Honor.
And Mr. Jimenez, as attorney for Mr. Rangel Torres, is this your signature on this document?
It is, Your Honor.
My understanding is this is an uncontested motion to revoke probation. Is that correct, Mr. Jimenez?
That's correct, Your Honor.
Okay, so on the first amended motion to enter adjudication of guilt and revoke community supervision, how does the defendant plead?
That's just to clarify, Your Honor, my understanding is we're pleading to the count for the dirty UA, to which we'll be pleading true.
I've got two. I guess we have three number two. So let's for the record call them 2A, 2B, and 2. I'm sorry, the first two, 2A and 2B, talk about consuming alcohol.
Judge, 1 second. Judge, 1 second. Mr. Torres, could you please mute your microphone because the wind is being picked up and we can't. I'm sure the court reporters have a problem. Thank you. All right, we're good, Judge. Sorry about that.
Okay, and I apologize. And the last one is number 5, which talks about failed to report by mail for the month of July 2016. So I guess my question once again is, how does Mr. Torres or Rangel Torres plead?
He'll plead true, Your Honor.
Fair enough. And Ms. Gross, would you please advise the court and the parties of the status of Mr. Rangel Torres probation?
Yes, Your Honor. Mr. Torres has performed poorly on probation in that he only reported 3 times. We last saw him on June 27th of 2016. He did pay in full $885. He completed 26 of his 26 hours of community service, and he did complete the drug offender education program. He did have 3 positive drug tests, 2 for alcohol and 1 for cocaine. This case did expire on September 27th of 2016. He has no criminal history, and we are recommending revocation.
Defense, what are you requesting?
Your Honor, we'd be requesting, if the court is inclined to not revoke Mr. Torres Rangel and let him complete some type of outpatient.
Okay, state recommendation.
Judge,
State would be recommending revocation and a JSAT.
Let me review my document real quick here. Hey, Mr. Rangel Torres, why did you stop reporting?
Because I came out positive for that alcohol and cocaine the last time I went to go do a UA.
Are you working, sir? What are you doing these days?
Yes, sir. I'm currently working. I've been doing landscaping for about going on 3 years, I think. Yes, 2018.
I'm sorry, you've been doing what for 2 years?
Landscaping.
Landscaping, thank you.
Yes, yes, sir.
Yes, Judge, and if I can add just a little bit of context, in my conversations with Mr. Torres Rangel, one of the reasons that he submitted for why he simply stopped reporting, he had DACA status at the time, and he was afraid that, if he was to be arrested, that immigration would come and pick him up. And so he understands that's not an excuse or a justification, but it did factor into why he stopped reporting. I would also advise the court, at the time of the violations, Mr. Torres Rangel was about 18 or 19 years old. He's now about 24. He's advised me that he's been clean. He has a 1-month-old child and has been working hard to turn his life around. Has been working, as he mentioned, for the last couple of years at landscaping.
Mr. Rangel Torres, you want to stay on probation? Basically, you're going to go through the same things you went through before. Are you willing to do that again?
Or Judge, I did not know that the state would offer a JSAT. I think that's something that we'd be inclined to do as well.
If I was you, I would be inclined to do that also. Unfortunately, I'm me, and I'm not inclined to do that because I have somebody with marijuana, alcohol, and cocaine. So my concern is for Mr. Rangel Torres and his family and children, if that still becomes an issue. So what I'm offering is, A, we can go by the textbook solution and just revoke him, find him guilty of the offensive possession of marijuana, and because I'm so kind and gentle, it'd be 90 days in jail. Or in the alternative, I will revoke his deferred, find him guilty of the offensive possession of marijuana, and keep him on 1-year probation period of time. He'd be eligible for early termination, but I'd put him in intensive outpatient with the Community Alliance for Traffic Safety and the standard stuff otherwise. DOEP courses, I think he's already done that. And whatever his original fine amount was, he would stay, he'd get credit for any monies paid or any programs he's done. So those are your two options. What would you like to do, defense?
I think the second option will be good, Your Honor. If I can propose an alternative, I don't know how willing the court would be for this. In an effort to allow him to keep his deferred, would the court consider giving him a long reset and ordering the intensive outpatient treatment, allow him to complete that while the case is pending, and then come back and see how he's done?
I'm afraid that ship has sailed about the time we were, 4 years ago when we stopped reporting or whatever it was. So that's not
Yes, Your Honor.
But that good try though. Good try for the defense.
Thank you, Judge. Got to take a shot at it.
All right. So Mr. Torres, what I have in mind for you is to revoke your deferred, and you'll be found guilty of the Class B offense of possession of marijuana. You'll be back on probation, and I'm going to give you an intensive outpatient drug course to talk about alcohol and cocaine and marijuana. I'm going to put you on weekly report in UA with the understanding that once you show me 4 clean weeks of UA, I'll put you back on monthly. As of right now, if I give you a UA today, you can be positive for marijuana and what else?
I'm not going to be positive. I'll be negative, sir.
Positive. Okay. Good answer. I like it. Working for it.
And if I can just throw something in to consider whether or not you want to do your jail time of, I think the judge offered you 90 days, or if you want to go back on probation, that intensive outpatient program is $695. And then you'll have to pay probation fees, which will be $30 a month. He'll give you credit for the other fees. So you're going to have some money that you're going to have to spend. So you might want to weigh that in on your decision. Just
Susan, let me ask you this, because I was unaware of that. The regular catnip outpatient drug course costs $95 or something. Is that correct?
$695.
No, you're talking about intensive outpatient. The regular catnip course, how much does that cost?
Oh, the regular catnip, that one is $125.
All right. Defense, with your permission, I'm going to go with the regular outpatient drug course, which is $500 cheaper, with the understanding that if we have any further drug issues, that we're going to talk again, which would be
I
probably.
understand, Your Honor. I think that sounds fair.
So Susan, I'm just going to order the regular catnip course. What was his original fine amount on this case, Sue, if you have it?
$250, Your Honor.
Okay. Okay, Mr. Torres, it was 5127773. The court accepts your plea of true to all conditions on the motion to revoke probation with an explanation. I grant the state's motion to revoke your deferred adjudication probation. I adjudicate you guilty of the offense of possession of marijuana 0 to 2 ounces. I sentence you to 1 year, excuse me, to 6 months in the Bexar County Jail for 1 year, assessing a $250 fine plus court costs. How many hours of community service did he have? 24, Susan?
26, and he completed them.
26 hours community service? Okay.
Yes.
And defense, I'm going to hold off on ordering a Smart Start mobile device. If we have an alcohol issue, we'll talk again on that one.
Yes. Your Honor, can I ask one question before we finish up here with this case?
Sure, go ahead.
My concern, now that I'm thinking about it, is his plea of true to the cocaine violation in the MTR. My concern is that immigration may try to use that as proof that he's actually guilty of possession of cocaine, which sometimes can cause people that are in his situation problems. Would the court consider allowing him to plead true to all the other violations and not that particular violation?
Sure. Let's just say for the record, he pleads true with an explanation to 2A and 2B, which are the two alcohol positives, and to 5, which is the failure to report. And he won't plead at all to the cocaine. Would that be helpful?
That'll be helpful, Your Honor. Thank you.
Okay. Let me start over. I apologize. Grant the first amended motion to enter adjudication of guilt and revoke community supervision. Finding Mr. Rangel Torres guilty of the offense of possession of marijuana 0 to 2 ounces, and sentencing him to 6 months in the Bexar County Jail, probated for 1 year, assessing a $250 fine plus court cost, 26 hours community service. DOEP course, Community Alliance for Traffic Safety and Intervention Program, outpatient drug, weekly UAs, credit for anything he's done or any money's paid. So any courses he's completed, he doesn't have to do again. And Susan, I caught it. It's not weekly reporting UAs, it's weekly UAs, correct?
You said it correctly, Your Honor.
All right, good. Okay, so Susan, what did I miss?
I think you covered everything, Your Honor. I just
Dave,
have
what
some
did I miss?
instructions when you're done.
Nothing that I'm aware of, Judge.
Okay, in addition, I'm requiring substantial compliance within 30 days, which means he needs to get registered for all these programs and get active in them. He's already done DOEP, right? And he's already done service.
Correct.
So he just needs to get registered for the CATSNP program within 10 days. He may not start within 10 days. He needs to get registered for his weekly UAs. And we're good on all that. Okay, Mr. Rangel Torres, you got any questions, sir?
No, Your Honor.
Mr. Torres, somebody will be in contact with you in regards to setting up your orientation. It will be done via Zoom. If you do not hear anything by like 2 o'clock on Friday, you need to call the probation department. You have a pencil where you can write a phone number down?
Yes, give me 1 second, please. Okay, I'm ready.
210-335-7200, and you're going to ask for intake. Okay, so if you don't hear from them by noon on Friday, you need to call them. It's your responsibility to get this done, okay?
Okay.
If you don't get your conditions signed and we haven't seen or heard from you, we're going to file another motion to revoke and you're going to be right back here, but you're not going to be as lucky next time.
Okay, yes, ma'am. And that is for orientation, right?
That's for orientation. They're going to give you all the information on your classes, who your officer is going to be, when your first report is going to be. You're going to sign all your documents and everything like that. Okay.
Okay, yes, ma'am.
And I will also be sending the probation application and a new data sheet that needs to be filled out. So I'll send it to your attorney first, and then it'll go to you. Okay.
Okay, thank you.
As soon as we're finished with the Zoom meeting, which will be in the next 30, 45 minutes, I'll send it.
Okay, thank you.
You're welcome.
Anything further from the state of the defense on Mr. Rangel Torres?
Nothing from the defense, Your Honor.
No,
Good luck,
Judge.
Mr. Rangel Torres. Thank you, counsel.
All right, thank you, Your Honor. May be excused.
You bet. Okay, next on my hit list is State of Texas versus Yvette Rodriguez, code 633-247, which is a motion to enter adjudication of guilt and revoke community supervision. Representing Mr. Rodriguez is Mr. John Reitmeyer. Mr. Reitmeyer, are you with us today?
Good afternoon, Judge.
Oh, there you are. Thank you, sir. And at this time, Mr. Rodriguez and Mr. Reitmeyer, I'm asking you to identify your signatures on two documents. First one entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. Mr. Rodriguez, is this your signature on this document, sir?
Yes, Your Honor, it's my signature.
Is it Miss Rodriguez? I apologize.
Miss, that's fine.
And Mr. Reitmeyer, is this your signature on this document, sir?
Yes, it is, Judge.
The next document is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt. Following a deferred adjudication, the defendant has a limited right of appeal, unquote. Ms. Rodriguez, is this your signature on this document, ma'am?
Yes, Your Honor.
And Mr. Reitmeyer, as attorney for Ms. Rodriguez, is this your signature on this document, sir?
It is, Your Honor.
My understanding is this is an uncontested motion to revoke. Is that correct, Mr. Rodriguez? Excuse me, Mr. Reitmeyer?
Yes, Judge.
And on the motion to enter adjudication of guilt and revoke community supervision, how does the defendant plead?
Similar to the others, Judge, it would be true with an explanation.
Okay. And Ms. Gross, would you please advise the parties and the court of the status of Ms. Rodriguez probation?
Judge, Ms. Rodriguez has done well on probation. We last saw her on February 23rd, 2021, while she was in jail. Her case is paid in full. She completed all 36 hours of her community service, as well as DWI education, victim impact panel, and CAT-SNP classes. She has had 3 positives for alcohol on the Smart Start mobile device, 2 diluted drug tests, 1 no-show, and 3 negative drug tests. While she was on Smart Start mobile testing at 6 times a day, she did have a high BRAC of 0.028 on October 25th, 2020, and has skipped 4 tests. Her officer has recommended that she remain on the Smart Start mobile device at 6 times a day for the duration of probation. She has no criminal history, and her case does expire next week on March 16th.
And let me back up a second. So basically, she's done everything she's supposed to do on probation for us, except she's still coming up positive for alcohol, and we have 1 diluted UA and 1 failure to appear for UA. Would that be accurate?
That is correct. And she's had 5 violation reports, and this is only the first time it's resulted in an MTR due to the COVID situation where all along you just amended her conditions.
That's like almost a new world record. Way to go, Ms. Rodriguez. But that being said, defense, what are you requesting?
Your Honor, we're asking you to continue her on her deferred. It expires next week, and as probation said, she's completed everything. The times of her .028, which is a very low BAC, as I understand it from the court summary, was at 6:59 in the morning, which could be explained by a few things. And I know Ms. Rodriguez has previously had a warning about things she eats triggering a BAC reading. Also that morning, you brush your teeth and take some mouthwash, you could have a BAC pop up. So it's our standpoint that it is a very low BAC. It was very early in the morning. And being that she has completed everything and expires next week, we'd ask the court to continue her and let this terminate on its own.
Let me back up. You brought up a couple of good points. The majority of these lows are apparently low, like under 0.03. There's one on August 1st, 2020 that's 0.065 at 6:44 a.m. in the morning. And we've already acted on that, so we're not going to do anything on it. But let's see. That was then, and this is now. State recommendation, please.
Along with probation, Judge.
Do what with probation? I'm sorry.
He said he agrees with probation's recommendation.
I got you. Hey, Ms. Rodriguez, what are you doing these days? Are you working? Are you going to school? Do you have any children? What's going on?
Yes, sir. Got a full plate. I'm working full time for USAA, 12 years now, almost 13. I've got 2 adult children, 20 and 23. They're trying to figure out life. I've got an 11-year-old and a stepson that comes and visits very often, both doing school online. I'm also caring for my 65-year-old dad that's got a lot of medical conditions. I'm his primary caregiver. So definitely a lot on my plate, sir.
I have you on the Smart Start mobile device currently, correct?
Smart Start and the GPS.
And I have you on GPS also?
Yes, sir.
As a condition of the bond, Your Honor.
I understand.
And Smart Start is 6 times a day.
Are you blowing 6 times a day on the Smart Start mobile?
I sure am, sir. I've kept up with those and I've not missed any.
How long have you been blowing 6 times a day on the machine?
A very long time. I want to say at least the last 5 to 6 months.
Susan, how long has she been on 6 times a day without having any problems or positives for alcohol? That sort of thing.
I think it's 5 months. It's 5 months.
And when does Miss Rodriguez terminate in a perfect world?
In 6 days, Judge.
6 days.
That's why we're asking to just leave her at 6 times a day and let her case term out.
Can you hang on for 6 more days, Miss Rodriguez?
You happy to?
All right, all good. Ms. Rodriguez, in cause 633247, the court accepts your plea of true to all conditions on the motion to revoke. Actually, it's a motion to enter adjudication of guilt and revoke community supervision. I deny the state's motion to revoke your deferred adjudication probation, or you continued on deferred adjudication probation and continuing all programs currently in progress, including Smart Start Mobile at 6 times a day. And if you can make it 6 more days, we'll terminate you satisfactorily. And I'm going to waive your GPS. Anything further from the state of the defense on Ms. Rodriguez?
Nothing further, Judge, but did I hear you correct? You said you were going to waive the GPS?
Yes, that's correct.
Thank you, Your Honor.
That was a good judge. All right. Good luck, Ms. Rodriguez. Thank you, Ms.
sir.
You won one. Way to go.
All right.
Thank you.
Thank you,
Ms.
Judge.
Rodriguez,
Yes.
just call your probation officer to let her know what happened today and see if she needs to talk to you for any reason. And just let her know that you are continued and you're going to stay on Smart Start at 6 times a day.
I appreciate that. Thank you.
All right. Good luck to you. Don't come back.
No, well, not. Bye.
Okay. We got Ms. Perez, it looks like. This one is clause 645148, Data Texas versus Ellie Marie Perez. This is a first amended motion to revoke community supervision. Representing Ms. Perez is Mr. Paul Vasquez. And I'm asking each of you about whether your signatures are on two documents. The first one entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. Ms. Perez, is this your signature on this document, ma'am?
Yes, Your Honor.
Thank you. And Mr. Vasquez, as attorney for Ms. Perez, is this your signature on this document?
It is.
Okay. Next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, as a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Is this your signature on this document, Ms. Perez?
Yes, this is.
And Mr. Vasquez, is this your signature as attorney for Mr. Perez, Ms. Perez on this document?
It is.
Mr. Vasquez, my understanding is this is an uncontested motion to revoke probation. Is that correct?
That is correct.
Okay. On the first amended motion to revoke community supervision, how does the defendant plead?
We'll plead true, Judge.
With an explanation, I'm sure.
Absolutely.
And Ms. Gross, would you please advise the parties in the court of the status of Ms. Perez probation, please?
Yes, Your Honor, Ms. Perez has done well. She has been reporting as directed. We last saw her on March 1st, 2021. She's paid $274 towards her fees, has a balance of $1,005, and she is current at this time. She's completed 36 hours of 36 hours of community service, as well as DWI education and victim impact panel. We have no record of completion or enrollment of the CATSNP program. She has had one UA, which was positive for alcohol. She's currently on Smart Start Mobile, testing it 4 times a day. To date, she has had 16 skip tests and 2 high BRACs. The first high BRAC occurring on February 8th, 2021 at 0.041 and February 19th, 2021 at 0.023. As for criminal history, she has a prior possession of marijuana and a criminal mischief 750 to 2500. And we are recommending that her Smart Start Mobile be increased to 6 times a day for a minimum of 2 months, that she provide weekly drug testing, she have 0 tolerance, and that she be registered for all of her classes within 10 days.
Mr. Vasquez, what are you requesting?
Judge, I'm also requesting that, and I've spoken with Nick about this case before, and he's also in agreement with that. If I'm correct, Susan, the only class left is the CATSNP, is that correct?
Yes, that's the only one that we have no record of completion.
That is correct.
Is she registered for CATSNP yet? Has she started it yet?
Ellie?
No, I was actually waiting just to have my hearing. I would have done it a while back, but I did speak to my PO about, when I would start it, because I could have done it at the same time I did the other 2 classes, but since everything was going on, it was just a lot to carry, especially with going to work every day and doing just always long hours. So I wanted to make sure that I understood what was going on here in the hearing and what was going to go on further because of my violation. So I can get started as soon as possible and enrolled and registered. I just wanted to know what was, the requirements that I was going to have today to follow through.
Why are you skipping 16 blows on the machine in 4 days? That's a lot.
Yes, it was my fault. This is my first time being on probation. So I had thought, I did discuss this with my PO on March 1st. She said no, that you're not supposed to skip it, period. I thought since I was in a warrant, I was supposed, it was okay, or not okay, but I didn't think that I would have to blow anymore because of the warrant, and because it's just me, myself, I'm not educated in what goes on in probation. So I did speak to my PO, and she did, make me understand and discuss with me that is not true, and that is not what I'm supposed to be doing. So I did go ahead and blow. She's like, it was supposed to be at 12. So I did go ahead and blow the next time that on Monday, I think it was on Monday. And I have been doing that because it was my, I was not educated on that and what I was supposed to be doing.
And Judge, just to be clear, she will enroll in the class within the 10 days, the CAT SNP.
Okay, and here, this is my big question of the day. The probation department says that on February 8, 2021, the defendant attempted to tamper with the outcome of the breath test in that the defendant is seen using a straw connected to a foreign device. What's that all about?
Yes, this is my fault. I do admit to that, and my honesty, it is my apology. I thought, I could get away with it. I did. It was my fault. I just,
What was the foreign device? How did you, this is sort of interesting because I haven't encountered this one before yet.
Okay.
Mr. Vasquez comes up with some good ones over the years. So what is the foreign device? How did the straw help you allegedly not get a positive for alcohol on a Smart Start mobile device?
To be honest, it was not my idea. It was my boyfriend's. I kind of went along with it, thinking that I could get away with it, thinking I don't, nobody would find out. And, of course that is wrong, because when you do wrong, of course, everything comes to light. So that will not happen again. It was with somebody else did blow for me through that straw. And I do apologize, and that I know that now that's a big mistake, and what are the consequences and what can happen. So from further on, I promise to do what I'm supposed to do on probation, as in taking, my blows and the UA test, just doing what I'm supposed to be doing, and not trying to be mischievous.
I understand the straw part of it. What's the foreign device part of it?
I don't know what the foreign device part
Judge,
is.
Judge, the foreign device is the straw.
Oh, okay. I don't know what that means.
So just for my educational purposes, Paul, if you don't mind me asking your client, did they say what the outcome would be by blowing through a straw was? Like it would lower whatever it would be, or it would negate it?
They were under the assumption, I think the boyfriend was telling her that it would be a negative, like it wouldn't show up any alcohol. Is that right, Ellie?
Yeah, like I just told him, just let's blow, because it's a violation anyway. I would just leave it alone. It's fine. And, it would be fine. And he's just like, well, what if you could pass it, because it gives you more time, I guess, on there. It gives you more time to, I guess, pass it, or to, I don't know what it does. This is my first time doing it.
Okay,
So
that was my question.
Yeah, that was just wrong. It was my fault.
Thank you for the honesty. I appreciate it.
Won't happen. It will never happen again. It's just idiotic. So I will continue to do the CAT SNP and enroll in that, as well as if I could do more blows a day, that'd be great. I just, my job doesn't pertain. It pertains how I look. So I would not like to be on that scram device or anything like that. So that is kind of where I'm at this point. So.
Okay. Ms. Perez, the court accepts your plea of true all conditions on the motion to revoke probation with an explanation. I deny the state's motion to revoke your probation. Or you continued on probation with all prior requirements and no sanction at this time, although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary?
No, sir.
All right, good answer. Altering in many conditions, modifying your Smart Start mode from 4 blows a day to 6 blows a day within 24 hours of right now, and adding weekly UAs, requiring substantial compliance in all other areas within 30 days. You need to be registered for the CAT SNP program within 10 days. Paul, once she shows me that if I get a 30-day period of time with no high brax for alcohol and no missed blows at 6 times a day, I'm going to put her back on 4 times a day. Okay. But I won't know she's done that if she does. She has to tell you, you have to tell me, and we'll do that. I'll just get it confirmed through.
Just to be clear, are you wanting to keep the weekly UAs where they are, or will you alter that as well?
Once she shows me from today 4 clean weekly UAs, I'll put her back on monthly. It's kind of the same thing we do with everybody.
Will do.
Yes, sir.
Susan, what did I miss?
Judge, I think you're good to go on that one.
All right. We can have
zero
problems with
compliance. Susan, did you say that, 0 compliance? Or is that Nick?
Sorry, say again, please.
Substantial compliance, 0 tolerance.
Yeah, substantial compliance is just my term, meaning that whatever she hadn't done yet, she needs to start doing within 30 days.
Will do.
Zero compliance will be bad, Paul.
Zero compliance, zero tolerance would be good. Zero compliance would be bad.
Got it.
All right, that's all I got. Anything further from the state of the defense on Ms. Perez?
No, Judge.
Ms. Gross, when does Ms. Perez finish her probation?
She's on until January 21st of 2022.
Wow. You might want to start going to church too, Ms. Perez. I'll get it going. Don't take any chances.